When dictatorship is a fact, revolution becomes a right. Hello everyone and welcome to Byjus IAS exam prep and welcome to another video in our knowledge series. Now in this video we will be discussing about the 1975 emergency in the context of Article 352. So at 6 a.m. on the 26th of June 1975, the ministers were informed that an emergency had been imposed at midnight, and then the announcement by the Prime Minister on All India Radio that the President has proclaimed emergency. There is nothing to panic about. This emergency is in response to a deep and wide conspiracy. A conspiracy because, as Indira Gandhi said, I have taken progressive measures for the upliftment of weaker sections, for the upliftment of women, and hence this conspiracy to overthrow me. And then began the arrests of student activists, arrests of trade unionists, arrests of Jan Sangh members, Congresso members, socialist members, any possible person who had any kind of inclination towards or association towards any of the other parties other than Congress were put behind bars. Under the draconian law, that is what was the MISA, Maintenance of Internal Security Act 1971. This law was also popularly called as the Maintenance of Indira and Sanjay Act. Now, later on, to further pacify, Indira Gandhi, in one interview that she gave to one Saturday Review in New York, said that emergency is not an abrogation of democracy. It is an effort to safeguard democracy. So those were the times. And then various people favoring the government wrote amazing lines on how emergency was justified. Quotations like, "Discipline makes nation great," or quotes like, "She stood between order and chaos." And then Indira Gandhi herself saying that this is a bitter pill that has to be given to the sick child that the country has become. So we saw all those times, difficult situations, plus a pre-censorship on the newspapers, magazines, no reports on processions, no reports on strikes, no reports on political oppositions, no reports on jail conditions could be published. And then somehow on some situations you'd find that some very interesting ads would be published. There was a very interesting obituary which somehow managed to skip the censors and got published in Times of India. This was an obituary mourning the death of Mr. D.E.M. Ocracy. A beautiful play of words on the death of democracy, and was mourned by the wife who was T. Ruth as Truth, and the son Libirtie, Liberty, and also daughters Faith, Hope, and Justice. So somehow these very few ads would skip through the censors' keen observant eyes and would make into newspapers, but strict pre-censorship, nothing could be published against the government. But eventually, how did we arrive at this situation? What went on and what went wrong that forced the government into taking such an extreme step? That is the story of the Indira Gandhi versus the Raj Narayan case 1975. This forms the background which pushed the government, or Indira Gandhi rather, into going for proclamation of emergency. So the case story is a very old one. Now in 1967-68, we saw the rise of Indira Gandhi as a Prime Minister, and then a split in the Congress later on. And finally, in 1971, elections were around the corner. Indira Gandhi, riding on the slogan of Garibi Hatao, contested elections, and the opposition members, who were earlier also, some of them were part of Congress, part of other parties, they came together to contest against Indira Gandhi, and they propelled somebody who was earlier a part of Congress, a very famous freedom fighter, somebody who could not be bought, who could not be purchased, who could not be coerced, a man of impeccable principles, one Mr. Raj Narayan. Now, Raj Narayan was known by a lot of people as a dharna expert of sorts. I mean, at any given point of time, if a group of people needed somebody to start a protest, they would call upon Raj Narayan. But it also remained a fact that this person was of impeccable integrity. So the opposition members propelled Raj Narayan against Indira Gandhi in the 1971 elections. Now, Raj Narayan was very sure of his victory, but to his utmost surprise, he lost the elections. And then came the plethora of conspiracy theories as to how he had lost elections. One contention that was doing the rounds was that Raj Narayan and people there pushed for this idea or this argument that Indira Gandhi had purchased chemically treated ballot papers from Soviet. And these chemically treated ballot papers, because back in those days, we had the ballot papers and not the EVMs. So there was a paper where you had to mark the symbol, the party you were supporting, and fold it and put it inside the ballot paper, the ballot box. So these ballot papers were chemically treated, and there was already a mark on the Congress symbol. It was already made, which was not visible. And when people would go and put the stamp, when the voters put a stamp in front of the symbol of Raj Narayan, it would slowly disappear when the boxes were stored, and the earlier mark, which was not earlier visible, would reappear. This seemed like a plot straight out of some 1970s Bollywood movie, but then sadly this was completely a conspiracy theory. However, the petitioners, the people who were opposed to the victory of Indira Gandhi, they went to and approached Shanti Bhushan. Now, Shanti Bhushan, being a very popular advocate, he said that these kind of contentions may not hold ground in court. Let us be more reasonable. Let us find out those charges which can actually hold ground, which have some merit in the court. One such ground that the petitioners used to file a case in the court, which also got accepted, was section 123, subsection 7 of the Representation of People's Act 1951. This was one section with this is one section which says that the use of government machinery to further your prospects of winning the elections is not allowed. It is a corrupt practice which can result in disqualification for 6 years. So somebody who is found using government machinery, for example, there were allegations that Indira Gandhi had used district officials to construct rostrums where she would give speeches. She used Air Force officers to fly her to various places. And she also used the services of her private secretary, the officer on special duty, one Yashpal Kapoor. Now, she was using government machinery, government officials, government resources to win the elections. This was a contention. Apart from other such contentions, like she was also found to be, or the claim was that she had exceeded the expenditure limit in the election while campaigning, or one more contention was that the Congress's symbol at that point of time was cow feeding its calf, and this was seen as trying to get Hindu votes, so using religious symbol in campaigning in elections. But finally, the Allahabad High Court where this case was filed, because it was an election dispute pertaining to the MP, the Prime Minister of India, Indira Gandhi. And that is why Allahabad High Court had the original jurisdiction in this case under section 99 of RPA 1951. And that is why the case was filed in Allahabad High Court. The court accepted this argument and then began the trial. A trial which began in the 1975, and initially the petitioners put forward this argument that Indira Gandhi had misused government officials for her private purpose for campaigning and making arrangements for campaigns. Now the problem here was one Yashpal Kapoor and his use as a election agent of Indira Gandhi. Now, Yashpal Kapoor said in the court that he had resigned on the 13th of January 1971, and this resignation had been officially accepted by Indira Gandhi on paper only on the 25th of January. Whereas from the 15th, 16th of January, he had gone to Raebareli and was busy making preparations for Indira Gandhi's campaign. But what Yashpal Kapoor and the lawyers of Indira Gandhi said was that on 13th of January, Yashpal Kapoor gave a resignation which was verbally accepted by Indira Gandhi on the 14th of January. Now Shanti Bhushan, the petitioner, said, is there any kind of rule which allows for this verbal acceptance of resignation? Then official documents make no sense. This was upheld by the court as improper, and the date of accepting the resignation was accepted as the 25th of January only. This meant that Yashpal Kapoor had gone to Raebareli and had campaigned for Indira Gandhi as her election agent while being a government servant. But later on, one more twist was brought by the lawyers for Indira Gandhi. They said that it's okay. We believe that Yashpal Kapoor may have gone and campaigned in Raebareli, but for whom? So the Shanti Bhushan and his lawyers said, obviously for Indira Gandhi. But then the lawyers for Indira Gandhi said, no, not for Indira Gandhi, because Indira Gandhi only filed her nomination on the 1st of February 1971. And this entire period where Yashpal Kapoor, while being a government officer, was campaigning for some candidate, may or may not have been Indira Gandhi, because Indira Gandhi also was planning to contest from Gurgaon. She had not decided. So the final decision was only made on the 1st of February 1971. So even if Yashpal Kapoor, while holding a government post from 14th of January to 25th of January, was campaigning in Raebareli, it was not for Indira Gandhi. So God knows who he was campaigning for. Now, this was caught hold of by Shanti Bhushan, and eventually what happened was, on the 18th, 19th and 20th of March 1975, the lawyers of Indira Gandhi brought Indira Gandhi to court. They felt that if Indira Gandhi, the Prime Minister, comes to court, the judges would not be so strict, and the lawyers would also not be able to grill her in the same fashion they were able to grill Yashpal Kapoor. But it was not the case. When Indira Gandhi came to court, immediately the contention whether she was the candidate from Raebareli or not was put in front of her. And Indira Gandhi constantly said that no, she had been a contestant from Raebareli only on the 1st of February. But finally, we were able to prove, Shanti Bhushan and the group of lawyers were able to prove that no, Indira Gandhi had willingly shown and also had addressed the press once the previous year on the 29th of December 1970 that she was going to contest from not Gurgaon but Raebareli. Once this was proved in and established in the court, Indira Gandhi was not only found guilty of Section 123, she was also found guilty of lying in the court under oath. And finally, on the 12th of June 1975 came the judgment of the Allahabad High Court, setting aside the election, declaring the election of the Prime Minister of India as void. And not only this, the court also disqualified her from contesting elections for 6 long years. Now, this is the classic example that the most powerful person of the country, the Prime Minister, had been toppled by a team of mavericks using nothing but just the legal system. And then the lawyers of Indira Gandhi got a stay order from Allahabad High Court to file a case in the Supreme Court. Now in the Supreme Court, Indira Gandhi hired who people knew as one of the best lawyers in the country, Nani Palkhiwala. Just 2 years back, Nani Palkhiwala had gotten a judgment which was not really in favor of Indira Gandhi in the Keshwanand Bharti case, where Nani Palkhiwala was fighting against Indira Gandhi for Keshwanand Bharti. Now, the contention started in the court, in the Supreme Court. However, this was month of June, and in the month of June, Supreme Court is on summer vacation. And during this period, only one vacation judge was sitting in the Supreme Court, and he was Justice V.R. Krishna Iyer, the same judge who later on also became a pioneer with Justice P.N. Bhagwati of the aspects like you have the Lok Adalats or the PILs. So V.R. Krishna Iyer was newly elevated to Supreme Court, and initially V.R. Krishna Iyer also claimed that he had received some phone calls from H.R. Gokhale, the then Law Minister, and he sensed that maybe the government was trying to influence him. He did not succumb to pressure, and finally a date was decided when Shanti Bhushan and Nani Palkhiwala, they met in Supreme Court to decide on the case with respect to the challenge of the judgment of Allahabad High Court. Now, the contention of Nani Palkhiwala was very simple. He said that let's delay the case as of now because you are a single judge. This is a very important matter. Let a priority bench or three-judge bench possibly decide. So let's wait at least for the Supreme Court to resume. Whereas Shanti Bhushan said there is no point of waiting for Supreme Court to resume. The Allahabad High Court has already found her guilty. The evidence is clear enough to continue with the disqualification. Now, Justice Iyer agreed on this point that yes, it should be decided by a bigger bench, definitely. But he also said that as of now, I am putting a stay order on the judgment of the Allahabad High Court, but Indira Gandhi will not be allowed to vote in the parliament. This was a reason strong enough to send a message to Congress that the evidence is very clear and this will possibly not hold in future against the judgment of Allahabad High Court. This evidence is heavily tilted in favor of the judgment and against Indira Gandhi. Eventually, they also felt maybe that once the Supreme Court, other judges also come in, maybe there is no possibility of any kind of change in the judgment. Anyway, so, and there were some biographers of Indira Gandhi who say that there was a fleeting moment when Indira Gandhi thought of resigning, but then maybe that was just a small instance where she must have thought of resigning and immediately a change of mind and then the declaration of emergency and the commitment of atrocities. Now finally, in 1977, when Indira Gandhi surprisingly thought that the country has improved, you know, on the 18th of January 1977, she addressed the people of the country during emergency, calling for elections, and she said, and I quote, "Earlier, the country was on a brink of disaster. It is now being nursed back to health slowly." So we are not really sure what kind of disaster the country was on, other than the disasters committed by the government itself. But then she believed, and she wanted the country to believe, that it was being restored, nursed back to health. And elections were declared on this supreme confidence that Congress would win the election. And then in the 1977 elections, Congress faced the biggest loss that it had ever seen since independence. It was limited to just 153 seats, and Janata Party, which was a conglomeration of Jan Sangh, Bharatiya Lok Dal, Socialist Party, Congress O, and also Jagjeevan Ram's Congress for Democracy. All these parties came together and defeated Indira Gandhi and Congress by securing 298 seats in the Lok Sabha. In fact, Indira Gandhi herself lost from Raebareli to the same person who she had defeated in 1971, Raj Narayan. Her son Sanjay Gandhi also lost from Amethi to some young student leader, and this was a case of emergency. Now, the performance of Congress was very varied. I mean, if you look at, say, the southern states, the performance was very good. Look at Karnataka. Out of 28 seats, Congress won 26. In Andhra Pradesh, Congress won 41 out of 42 seats. But the performance was terrible in the northern states. States like UP and Bihar, where Congress could not get a single seat. States like Rajasthan, 1 out of 25. Madhya Pradesh, 1 out of 40. And this was largely because of some orders issued by the government, especially the order of forceful vasectomies being conducted to control population. Now, Sanjay Gandhi also believed that population explosion is a real problem and we have to keep a check on population, and that is why targets would be given to various government officials on how many vasectomies had been conducted on the people in that week, in that month. Now, this forced vasectomies became a very emotive, very explosive issue, which led to the Congress performing very, very poorly in the northern states, eventually resulting in the fall of Congress government. Anyway, when the Janata Party came to power, various people became ministers. We saw the rise of Madhu Dandavate, who became the Minister for Railways. And then for the first time in the second class of railways, we had foam seats. Then Charan Singh became the Home Minister. Jagjeevan Ram became the Defence Minister. H.M. Patel became the Finance Minister, with Mr. Desai becoming the Prime Minister of India. Now, see, Janata Party was a group of various parties with different ideologies coming together. It could not survive. And eventually in 1980, the party collapsed, elections again, and this time Congress came back to power. So this was the Indira Gandhi versus Raj Narayan case. Now, along the same lines, the case primarily was, or the issue of emergency came from the constitutional provisions that are there in the country with respect to emergency. So we have three types of emergencies. First one is the national emergency, which is known as proclamation of emergency, which is Article 352. And other related articles are 353, 354, 358 and 359. Then we have something which you know as the President's Rule. President's Rule, or the state emergency, or the constitutional emergency. This is Article 356, though there are some other articles which are associated like 355 and 357. And then we have financial emergency. This is Article 360. As far as financial emergency is concerned, it has never been imposed so far. As far as the national emergency is concerned, it has been imposed 3 times. One during the Indo-China War, one during the Indo-Pak War of 1971, that is the Mukti Juddha or the Bangladesh Liberation War, and one that we know as the 1975 emergency. And as far as President's Rule is concerned, it has been imposed over 100 times, 115 times till 2016. So it has been misused a lot. Anyway, so what about national emergency? What are the conditions? So national emergency can be imposed by the President, but the President has to be satisfied. And when I say satisfied, the satisfaction is not of the President, but on the written communication of the cabinet ministers. Ministers of the cabinet rank, they have to be satisfied and they have to give in writing that conditions exist that require the imposition of emergency. What kind of conditions? 3 possible conditions. There should be an imminent danger of either war, imminent danger of external aggression, or armed rebellion. Now, this phrase armed rebellion was not there originally. Originally, what we had here was internal disturbance, which was used by Indira Gandhi to call for emergency, because Jayaprakash Narayan had asked the country to rise up and revolt against this autocratic and despotic regime. This was used by Indira Gandhi to showcase that, see, the opposition members in this country are trying to create internal disturbance in the country, and hence the imposition of emergency. When Janata Party came to power in 1978, they made a modification in this Article 352 by changing and replacing internal disturbance with armed rebellion. This was the modification made by Janata Party in 1978. Now, when the emergency is proclaimed and imposed by the President, it has to be approved by the Parliament within 1 month of its proclamation, or else the emergency will have to be revoked. So the Parliament, both the houses separately have to vote for it with a special majority. When I say a special majority, it means more than 50% of the total strength of the House and at least 2/3 members present and voting. And beyond that, once the Parliament approves national emergency, it can only continue for 6 months at a time. After every 6 months, it requires the same kind of approval by a special majority. So after every 6 months, the Parliament has to approve the continuance of the national emergency, and then it can continue indefinitely. So this is the provision with respect to imposition of emergency. Now, what if you want to remove it or revoke the emergency? So obviously the President has full power and authority to revoke the emergency. When I say President, I mean to say the Council of Ministers, the Prime Minister. Beyond that, the Lok Sabha also has the power to revoke the emergency. This is a special power of Lok Sabha. So, if 1/10 of the members of Lok Sabha give in writing to the Speaker, and if the House is not in session, then give in writing to the President. And if they give in writing that we want to revoke or remove emergency, then a special sitting has to be conducted for the Lok Sabha, only Lok Sabha, within 14 days of receiving the notice. And in that special sitting, voting will take place, and if by a simple majority, meaning more than 50% of the people present and voting, if they approve of this resolution, then the emergency can be revoked. So just understand that imposing an emergency requires a special majority, but removing it requires a simple majority. Very easy to remove it, very difficult to impose it. So these are the conditions with respect to imposition and revocation of the national emergency. Now, what are the effects? First up, we have the executive effects. So when it comes to national emergency, the executive effects means that now the center has complete control over the states. States are under complete control of the central government, and center can issue binding directions to states. Beyond that, there are some legislative effects. Article 250 says that the center, the Parliament, can make laws on even stateless subjects. Even though states can also continue to make laws on stateless subjects, but Parliament has overriding majority. So that is what is the legislative effect. Beyond this, the tenure of the Lok Sabha or the Legislative Assembly can also be extended by 1 year at a time. Normally, the tenure of Lok Sabha or the Assembly is fixed at 5 years, but during the national emergency, it can be increased by 1 year at a time, which was done in 1975. It was done twice to increase the tenure of the Lok Sabha by 1 year at a time. And then we have financial effects. Now, when it comes to financial effects, during the proclamation of national emergency, the center is also empowered to alter the distribution of revenue between union and the states. However, this should not exceed beyond the expiry of that financial year in which the emergency ceases to operate. So these are the executive, legislative and financial effects during national emergency. And lastly, the effects of emergency on the fundamental rights. So these two articles under the emergency provisions relate to the effects on fundamental rights. These provisions have been borrowed from the Constitution of Weimar Republic of Germany. Now, Article 358 says that during the proclamation of national emergency, and if national emergency is proclaimed on the grounds of war or external aggression, in these two circumstances, the Article 19 that you have, the right given to every citizen, the freedom given to every citizen of speech and expression, to assemble peaceably, to form associations, to reside anywhere, to travel anywhere, to practice any profession, occupation, trade or business, this right of Article 19 gets suspended automatically when a national emergency is imposed on grounds of either war or external aggression. However, under Article 359, if emergency is imposed, if national emergency is imposed on any ground, be it war, be it external aggression, or be it armed rebellion, then the President can issue an order and can at any given point of time suspend the right of the people to move to court for the protection of any fundamental right. So, this means that the rights are not suspended, but you can't move to court during emergency to protect those fundamental rights. This is what happens under Article 359. Now, a very interesting change has been made in 1978, and this also warrants a brief discussion. This is the very famous ADM Jabalpur case. ADM Jabalpur versus Shivkant Shukla, a black letter day in the history of Supreme Court of India. And this was a case when Supreme Court came out as a committed judiciary, committed to upholding the principles, the policies of the government. This ADM Jabalpur case was a case based on the law MISA, Maintenance of Internal Security Act. Now we are all aware that under MISA, lot of people were arrested, and there was a section 18 under the law which said that the detention could not be challenged on any ground, including Article 21's violation. Now, Article 21 is a right to life. How can the government take away right to life without giving any reason, without following a procedure? So, in this case, this section 18 of the law was challenged. It was a 5-judge bench, and interestingly, the 5 judges were Justice A.N. Ray, who was the then Chief Justice, Justice M.H. Beg, who later on became the Chief Justice, Justice P.N. Bhagwati, who became the Chief Justice later on, Justice Y.V. Chandrachud, the longest sitting Chief Justice, and the 5th judge, Justice H.R. Khanna, the only person who could not become the Chief Justice. Despite being the senior most in 1977, he was not elevated by Indira Gandhi, and Justice M.H. Beg was elevated, and you will know shortly why. So these 5 judges sitting on the bench together and decided whether the government has a right to even take away Article 21 or not. And sadly, the Supreme Court upheld the section 18 of MISA, stating that the right of government to suspend all fundamental rights is appropriate. And this was seen as completely violative of Article 21. The only judge who dissented was Justice H.R. Khanna. The judgment was 4:1, with 4 judges agreeing and 1 judge dissenting. Justice H.R. Khanna said that Article 21 is not the only source of life. Rule of law protects life. And you know, this judgment showcased that and is a classic example of the submission of an independent judiciary to an absolutist government. And this is the last step in the destruction of democratic society. The dissent of H.R. Khanna proved to be very costly for him. In 1977, he was not elevated to the post of Chief Justice despite being the senior most judge. Justice M.H. Beg, who had given a favorable judgment just the previous year in 76 in the ADM Jabalpur, was made the Chief Justice. Justice Khanna readily and immediately resigned, rightfully so. So this was the ADM Jabalpur case. Now, when Janata Party came to power, it tried to undo this wrong. So in the provisions of Article 359, Janata Party made a modification. It said that during national emergency, the president can issue an order and can suspend the right of every individual to move to the court for the violation of any fundamental right except Article 20 and Article 21. And we know very well that Article 21 can never be suspended now. Even during a habeas corpus, even during martial law, habeas corpus, the right to move to court to claim right to life can never be suspended. So this wrong was undone finally by the Parliament in 1978. And now you cannot suspend Article 21 at any given point of time, even in case of national emergency. So these were the provisions with respect to the imposition of emergency in 1975 as well as Article 352. Let us take some questions that you have. Questions, please. Should High Court and Supreme Court's judicial executives be given post-retirement posts? If you refer to judges as soon as they get retirement, this is some kind of bribery. Now, what kind of post are we talking about? We have seen situations where judges have been made governors. P. Satasivam was made the governor. We have also seen a case where a former Chief Justice accepted the nomination to Rajya Sabha. Now, yes, ideally the judges should refrain from choosing such posts. It does not behoove of the authority of the judge. Any which way, we already have a provision under Article 124, Clause 7, which says that the people who have retired, the judges who retire from Supreme Court, they are debarred from pleading in any court of law. So you can't practice in any court of law, but there can also be modifications made to prevent such kind of appointments. Definitely. It may not be a bribery always, but sometimes some things are simply outrightly unethical. And as we always say, justice should be done. It should also be seen to have been done. So in such cases, fingers will always be pointed towards the judges, irrespective of whether it is a bribery or not. Can the president modify the constitutional distribution of revenues between center and the states? Yes, the president can modify. As I said, that is what is the financial effect. So during the proclamation and during the national emergency, when it is in force, the distribution of taxes between center and states can be altered. However, this alteration will only continue till the end of that financial year when the emergency ceases to operate. So let's say emergency ends today. So the 31st of March 2023 will be the date till which the distribution of revenue modifications will apply. If the emergency ceases to operate on the 5th of April 2023, then the distribution of revenues which has been altered can continue till the 31st of March 2024. Can elections be held? Obviously, there is no issue as such with this. Was MISA was the primary act which was used to curtail the freedom of speech of people and put people behind bars. Eventually, there were various laws which were used to prevent or curtail any kind of dissent. But sending people in jail, for that purpose, MISA was a law which was used. Why do we need a constitutional emergency? So Article 356 can be used for various circumstances. First up, one big issue could be if no party gets the majority, if no party is able to form the government in the state after the elections in the state, then it would be fit for the imposition of president's rule. If the state is not abiding by a direction given by center on a topic over which center has the power to make laws, meaning if the center tries to give directions to the state on topics say under union list and the states are refusing to follow the directions, then it can be imposed. Or if the states do not, or states follow policies which are opposed to secularism, even then the President's rule can be imposed. Ideally, Article 356 simply says that President's rule can be imposed if there is a failure of constitutional machinery in the state. If the provisions of the government in the state cannot be carried on in accordance with the provisions of the Constitution, then the President's rule can be imposed. Okay. For national emergency, it is a cabinet which will give its recommendation, a written recommendation. As far as financial emergency is concerned, the only condition with respect to the imposition of financial emergency is that the financial stability or the credit of India is under threat. There is no categorical definition of what these words mean. That is all that is written under Article 360, that the financial stability or the credit of India is under threat. Systematic and targeted oppression of dissidents, unproclaimed emergency is a real threat. That's obviously going to be the case whenever we have the governments trying to curb the freedom of speech and dissent. This obviously means that the government is not willing to be questioned. And in a democracy, dissent, the power of people to question, is the ultimate power that we have, holding the government accountable. So this is all that was there as far as the 1975 emergency was concerned. That's all for this video. Jai Hind.